Good morning, everyone. Welcome to our webinar on Digital Personal Data Protection Act 2023, Navigating India's New Data Privacy Regime. Before we begin today's session, let me briefly introduce myself. I am Drivya Jain, a senior associate lawyer at eMinds Legal with over 5 years of experience in corporate and IP laws and DPDP related compliances and data privacy. Coming to eMinds Legal is a boutique corporate law firm in India specializing in corporate legal, corporate secretarial, compliance and accounting, tax and payroll. The firm comprises of a team of around 70 professionals with in-depth subject matter knowledge and participative industry experience of over 15 years. I am also delighted to introduce our speaker for today's webinars, Dr. Sumit Pava. Hi, Dr. Pava. Dr.
Yeah. Hi, Drivya.
Dr. Sumit Pava is a corporate lawyer, company secretary, MBA, FMS, and a PhD in emotional intelligence. With over 27 years of experience in governance, risk, compliance, and business management, he is the founder partner of eMinds Legal, a boutique corporate law firm in Gurgaon, and a co-founder and CEO of Complinity Technologies, which is India's leading compliance software. He is also an independent director with many companies and adds value to the boards through his business acumen, legal experience, and a strong leadership skills. Dr. Sumit is the lead author of 12 books on Companies Act 2013 titled Corporate Law Referencer and is a regular speaker at various events and webinars on law and compliances. Thank you, Dr. Sumit, for joining us today. Imagine starting your day by unlocking your phone, booking a cab, making an online payment, checking your email, and scrolling through social media. In just a few minutes, you have shared your location, contact details, financial information, browsing history with multiple organizations. Every click creates data, and every piece of data deserves protection. That's where the Digital Personal Data Protection Act 2023 comes in. DPDP Act has marked a transformative step in India's data protection landscape, establishing a comprehensive framework for collection, processing, storage, and protection of digital personal data. The Act introduced significant obligation for organizations handling personal data while strengthening the rights of individuals to control how the data is used. With the issuance of DPDP rules, organizations must reassess their data governance practices, privacy policies, consent mechanisms, and cybersecurity measures to ensure compliance and mitigate regulatory risk. The key takeaways of this session will be overview of the DPDP Act and the DPDP rules and its key provisions, understanding key concepts, personal data, data principal, data fiduciary, consent, and legitimate users, rights of data principal and mechanism for handling their request, obligation of data fiduciary and data processors, security safeguards and data protection measures expected from organizations, penalties, enforcement mechanism, and regulatory risk under the DPDP framework, gap assessment and operational readiness review, implementation of DPDP Act, cybersecurity audit, and interactive Q&A session with industry experts. I hope this webinar helps you better understand the DPDP Act and its real-world implication for organizations. Before starting the webinar, let's start with a quick opening poll. Your responses will help our speaker better understand the audience and tailor today's session accordingly. Please take a moment to participate. Just a quick note, this session is being recorded and the recordings will be uploaded to our YouTube channel. You can also follow us on social media and the links are in the chat box. So from the poll results, I can see that a lot of practicing professional and consultants have joined. Then there are general counsels and legal teams, IT and data privacy team. Thank you. Over to you, Dr. Sumit.
Okay, so Digital Personal Data Protection Act, or as we call it, DPDP, and navigating India's new data privacy regime. So this is the first data privacy law in India, as you all know. Prior to that, there was only an IT Act, so first law. And today we are going to cover the overview of the entire law, the DPDP Act and the rules. And this being a so important law, and right now we are standing in the middle of the implementation phase. So we'll be hosting a series of webinars on DPDP on specific topics, niche areas. But today, being the first in the series, it will cover an overview of the Act and the law and the key definitions and the concepts, etc. So this is India's first, primary law governing digital personal data to protect the privacy of individuals, and enacted in August 2023. However, the rules only came in November 25, and a phased implementation is required by April or May 2027, and it applies to Indian and foreign entities processing Indian data in digital form. So three things here. Entities could be Indian or foreign. They have to be processing Indian data, that is data of the Indian people resident in India, and in digital form. These are the three sort of concepts. We'll cover it in detail, and applies when goods or services are offered to individuals in India, could be from foreign companies, as I said. Both private and public sector entities are covered. So, unlike earlier, not just private, even the government is covered, the public sector undertakings are covered, the entire private and public sector regime is covered. It also introduces a new regulator, Data Protection Board of India, DPBI, which is under formation as we speak today. And this did not exist earlier. It's a new regulator. Something which has been often making the news is the 250 crore penalty, which I think everyone has been talking about, and aligns India with global privacy standards like GDPR. Again, GDPR has been here for times immemorial. It was really high time when India adopted its own data privacy act, and that's where the beginning has been made. And since we talked about GDPR, and GDPR also has been applicable even in India if the data of the people in the EU was being processed in India, and again there were huge penalties. So it's very important to draw a high level parallel between DPDP and GDPR. So the scope is only digital personal data is covered, or data that is digitized as far as DPDP Act is concerned. Here in GDPR, it is all personal data, whether it is digital or non-digital, that is covered. So this is one difference. It uses the term, the DPDP uses the term called data fiduciary, which means any company which is collecting the data and has a purpose and means of processing the data. So could be retail chains, could be hotels, could be hospitals, could be any company. No industry is defined. A simple company with one manufacturing plant also is collecting data of customers, vendors, employees, individuals, etc. So this is data fiduciary, and data processor means if the data fiduciary is giving on a contract basis, say a contract to a HR service provider, for payroll processing or tax compliances, etc. So some personal data is being shared. He's a data processor who is processing data on behalf of data fiduciary. In GDPR, the term uses data controller, and the key difference is in DPDP, the data fiduciary is alone responsible, even on behalf of data processor, like a principal employer in, if I draw a parallel between labor codes. Here in GDPR, all data controller as well as data processor both have specific obligations and responsibilities. Now, applicability. DPDP is applicable to related to data principals located in India, even if the data is processed outside India. Say, for example, Facebook or Amazon or Google, if they are, of course, they are giving services in India to the Indian nationals and residents. Even if they have servers abroad, even if they do not have any presence in India, DPDP will be applicable to them. Similarly, in GDPR, data related to data principals in the European Union was covered, even if it was processed in India. So it's actually vice versa. This is an Indian legislation protecting data of the Indian nationals and residents. And of course, GDPR was protecting the EU residents and nationals. Now, breach notification. Here in DPDP, breach notification is required for all personal data breaches. However, so the key point is the breaches, the key personal data breaches. Here in GDPR, it was not just the breach only. It was even if it was likely to result in a breach, the reporting was to be done, and there was some risk-based threshold which applied. Now here it also introduces a concept of consent managers. So it's a separate class of companies, and we'll cover it in later slides to help manage the consent which is to be required from data principal. In GDPR, there is no consent of consent manager. In cross-border data transfer, it is generally permitted unless restricted by the government. So there are no data localization requirements unless, as per the rules, government restricts it. However, in GDPR, it was the opposite. It said data transfer is allowed only where the EU granted the adequacy status. So it's like transfer only when approved or maybe by the rules, etc. Here it is transfer unless it is restricted. So it's like that. Children's data. So children have been defined as children under 18 years of age. It requires processing of children's data requires parental consent or guardian consent. In GDPR, the children have been defined as under 16, or sometimes even by member states under 13 also. So that's one difference. Here the penalties are up to 250 crore as we talked about. There the penalties are up to euro 20 million or 4% of global annual turnover, whichever is higher. So virtually no limit, very humongous penalties in GDPR. Here also 250 crore is of course not a small benchmark by Indian standards by any means. It is a huge sum. Now, need for DPDP Act. You would say that the IT Act already existed, so what was the need of DPDP Act? Now, you would agree that rapid digital transformation has been taking place in India. Gone are the days where everything was manual. In the last 15 years, we have seen on the consumer side, we have seen the Amazons and Flipkarts, and now even the Zomato, Swiggy, the quick commerce, and the porter and so means the immediate deliveries and stuff. So e-commerce, e-governance, the softwares, and now even AI. Everything is transformed in the last 15 years. If you just notice, in fact, there was no Facebook, LinkedIn 20 years back, right? And or maybe 20, 22 years back. They all happened in the last 20 years. So it has been a rapid digital transformation without matching safeguards. So all we had is one Information Technology Act, which was again very old, with some rules of 2011, again not keeping up pace with the rapid collection of data, processing of data, the rapid digitization which happened in India, and therefore it was need of the hour and increasing data breaches across critical sectors. So the be it hacking or be it cyber crimes, be it digital arrest or be it rampant misuse and abuse of sort of data across sectors that was happening. And privacy was recognized even as a fundamental right in the Puttaswamy judgment in 2017 by the Honorable Supreme Court. And ever since, the data privacy bill has been in the parliament and went to the standing committees and has seen several versions, even the renaming of the DPDP. It was earlier PDP Act, etc. So now the unregulated collection and monetization of user data has happened, be it telecom data, your mobile numbers, your Aadhaar cards, PAN cards. Several organizations are collecting all these KYC data also, especially banks, financial institutions, telecom companies, even hotels, hospitals, wherever we go. Aadhaar, PAN, and many more, personally identifiable information is rampantly accessed. Even, our biometrics, the iris scanners. So we are continuously sort of giving out data. Just imagine one more thing. For example, you go to a as Divya introduced in the beginning, you book a cab, you pass on some data. You go to a store and buy something, you pass on some data. You come back to you maybe you're passing through malls, your CCTV footages and everything is being scanned. That's also data. You come to your office and sign in with not sign in, just open the gates with your biometrics and all. That's another set of data. Then there is medical data, records. There are intermediaries. There are digital e-pharmacies also. There, a lot of prescriptions, medical records are going. So data everywhere is there. You buy a vehicle, you pass a lot of data, etc., etc. So it's a lot of data getting sort of collected, and we do not know whichever data is being collected by these organizations, how are they storing it, storing it? How are they sharing it or using that data? Are they sharing it with people whom we have not consented, to be shared? How are they monetizing that data? Is this data being sold to, say, fintech companies or insurance companies or other companies, etc., for their marketing or sales purposes? So we do not know any of this. And there are no clear rules on consent or purpose limitation. Children's data needed an urgent attention, and there was a need for regulating all this government access, even the government access to data. So government has even more data than the private companies, have. And which department of government can access what data? How can they use it? What is the purpose? Will the data be erased or will be retained forever, etc., etc.? Cross-border data transfers. Now, for certain critical sectors, there are specific regulations for data localization in India, especially finance, and RBI may prescribe for banks, etc. But now in DPDP Act also, government may identify critical sectors. They may see the sovereignty and the integrity and the security of India, and then prescribe what is allowed, what is not allowed under the rule making powers and all, and notification powers, and absence of an independent regulatory body. So uh, again, we need a separate cell, a separate specialized set of professionals and tribunal and a body which can look at all these data. Just give me a second. Yeah. Now, the earlier scenario, as we discussed, was Information Technology Act, focused on e-commerce and cyber crimes and digital signatures. No comprehensive personal data protection mechanism existed. Address unauthorized access or hacking, but not misuse of personal data as such. And there was a regulation, as I was mentioning earlier, Sensitive Personal Data or Information Rules, 2011. It was issued under Section 43A of IT Act. And this was the only section and the only set of rules which little bit talked about sensitive personal data, and required the organizations to adopt privacy policies, security practices for service companies, ISO 27001 on data security, etc. And it only applied to body corporates and not government. So limited regulation primarily by way of one set of rules and limited obligations under the overall IT Act of 2000. So the legislative journey of DPDP has been, that it was passed on 7th of August 2023 in Lok Sabha, and then 9th August passed in Rajya Sabha. So 2 days later Rajya Sabha, 2 days later President assent received, uh, because all the parliamentary standing committees and all had earlier approved these drafts before 7th August. Then 24th November, the final set of provisions were enforced by virtue of a notification, and 14th November 2025, that is exactly 2 years from the time when DPDP Act was notified, the DPDP rules came in, DPDP Rules 2025, which is when the entire talk about the implementation of DPDP started, the entire heat and the action about the DPDP started. So now is the time. And what are the enforcement timelines? Phase 1, 14 November 2025, when the rules were notified, the definitions came into force. The appointment and establishment of Data Protection Board of India under Section 14 to 19, commencement of the Act, and general rule-making powers. So basically enabling provisions, blanket provisions, which can enable the formation of DPBI, the Data Protection Board of India, and with the rule-making powers under the DP Act. Then phase 2, within 12 months, so this phase is still going on, that is until November 2026 this year. The consent manager, there's a concept of consent manager. So this should be an Indian company with net worth over 200 crores, and there are a few more guidelines or conditions for being a consent manager. So it's a separate class of business, I would say, being proposed, consent managers, which will act as an intermediary between the data principal, which is all of us as individuals who are giving their data, and the data fiduciary, which are the companies or any other person who is collecting the data. So between the data giver and the data receiver, somebody to manage the entire paraphernalia of consent and the withdrawal of the consent and the purpose and the limitation. So the entire class of companies will act as a consent manager, a separate intermediary. We assume they would have IT platforms. They would make it easy for all industries and all sorts of companies to enable their consent mechanisms for their customers or their vendors or their data principals, etc. Though there are rules which have been notified under the DP Act, there are clear guidelines who can be consent managers, how they will operate. But the consent managers themselves will require registration or approval from the government, which is the phase which we are in. And as we speak, I think some applications may have already gone into the government. They may already be evaluating who can be the consent manager, etc. And then some additional requirements and rules may come up. Then phase 3 is the main phase, which is full substantive compliance within 18 months of notification of rules. That is till May 2027. So this requires consent and notice under section 456, the data principal rights under section 11 to 14, duties of data fiduciaries section 8 to 10, data processor responsibilities under section 8, cross-border transfers, security and breach, exemptions. So pretty much the whole act and the whole of the rules will come into play on May 2027 or till May 2027, because the act says 18 months, sorry, the rule says 18 months from the notification of rules is when the whole act and the rules will come into picture. So today we are on June 2026, and it is less than 12 months now when the whole act will be enforced. Therefore, it's very, very high time for all the companies now to not only understand what is DPDP and the definitions and all these concepts, but also start implementing. And towards, as we progress through this webinar, not only I'll be covering a few concepts and definitions, etc., we'll be covering practical examples and practical implementation steps as to now what means after completing this webinar, what is the next step that you need to take, or you might already be taking, and that will get validated, from this. So key definitions, data. So data is any representation of information, facts, concepts, opinions, instructions, etc., in a manner suitable for communication, interpretation, or processing. So very, very wide definition. Everything is data. A person's name, address, age is data, salary is data, student's project is data, doctor's opinion is data, digital platform usage, including your search history, location, all that, everything that you are signing, whenever you're downloading apps and giving permissions for camera, gallery, location, contacts, everything is data being collected by companies. So data is very wide. But what is personal data? Personal data means any data about an individual. So the key point to be noted is individual, which is you and me, who is identifiable by or in relation to such data. So now this becomes a personal data. That means suppose it's say a GST return. It is not personal data. Suppose it's another sort of a company law, AOC 4 under Ministry of Corporate Affairs. Something which is a corporate compliance, something which is a company data, and that to aggregate, and it does not contain any personal data of an individual, then that is not personal data. And what DPDP protects is the personal data. So this is one, I think, correction that we must do. It is not that everything, of course, everything is confidential. You may have confidentiality clauses with your contractors, vendors, customers, etc. So, but what is being sought to be protected by DPDP is the individual data, the personal data. That is, for example, your name, your age, your address, any information that identifies you as a person, your biometric, your iris scanners, your medical records, health and sensitive information, what we submit to the hospitals, your KYCs, Aadhaar card, PAN card, driver license, even your education information, your degrees, passports, all of that. And online identifies even your IP address, your device ID, your mobile IMAP, or whatever that is called, IMEI number, your financial information, income tax returns, all of that is personal data by which you can be individually identified. So this again still a lot of data. And digital personal data is the term used. It means personal data in digital form. That's the definition. So whenever your personal data is stored in digital form, collected, stored, processed, or transmitted in digital form, it becomes a digital personal data. So your online account information, your digital contact information, digital financial data, government ID data, like DigiLocker, for example, or digital health records. So even you go to any hospital, all our health records are like digitized. They have their cloud-based softwares. All our patient ID or UHID, whatever that is called, that is a unique ID. and our health records are pretty much there, and digital communication. So even for that matter, if you are, say, typing in your personal data, say, or writing it on a form, and it's a 5-pager form, 3-pager form, and that data is subsequently scanned and kept in somebody's server, even that is digital data. So a handwritten data, but for later scanned and put on the server, also becomes a digital data. It need not be only processed through servers and stuff like that. Now, data fiduciary. Data fiduciary means any person who alone or in conjunction with other persons determines the purpose and means of processing of personal data. So again, see, definitions are being used within definitions. So now we are saying personal data. We have seen what is personal data, which identifies you. Now, data fiduciary means whoever is collecting your data and has a purpose to collect that data. And I'll tell you what the purpose means. For example, these e-commerce platforms, banks and financial institutions, telecom companies, EdTech, passport office, and many more. Even a normal company, as I said, be it a service company or a manufacturing company, uh, they have a purpose to collect a customer data or the vendor data or the employee data. So that is the purpose. The data processor is the next definition. There they do not have the independent purpose. So the only purpose of a data processor will be that the data fiduciary outsource certain work to data processor, and that's why they're processing. But they do not have the purpose to process the individual data. The only thing is the contract by which they have been outsourced. So data fiduciary is like a principal employer. Again, in labor law parlance, he is a principal. Is a principal. But do not get confused with the word principal, because here data principal means you and I. Data principal means the individual to whom the personal data relates, and where such individual is a child, then his lawful guardian or parents, and even a person with disability, his lawful guardian. So you and I shopping on Amazon, or somebody visiting hospital. I'll not say you and I visiting hospital. Why should I say that? But of course, anyone visiting hospital, a patient is a data person using a mobile app that you and I use, and a social media user you may use. I am slightly lesser on social media, but any which ways, all that is a data principle. All the individuals who are uh, giving out data are data principals. Now, as I said, data processor is the contractor. So person who's processing the personal data on behalf of a data fiduciary. So data processors do not decide the purpose or means of processing. It's a fiduciary who decides that. For example, IT and cloud service providers like Microsoft Azure, even companies like TCS, Infosys, if they are giving certain services to their end clients, even GCCs, global capability centers, the BPOs or the ITES companies all over India, they are processing a lot of data, including when they are behind the financial services companies or banks. They may be processing bank account informations, credit card. For example, credit card support centers, call centers. They have a lot of personal information about our credit history, about credit card details, numbers, so many other things. So all that, they may be data processors, but the fiduciary would be, suppose if it's an American Express credit card, so Amex would be the fiduciary. And suppose they have outsourced their support to some third party, then that third party would become the data processor. Then applicability and exemptions. So to whom it is applicable, Section 3 applies to all digital personal data. Now we have seen the definition: data, then personal data, then digital personal data. So digital personal data, which is collected digitally or collected offline but later digitized, as I was saying. Even if it's collected in a form, but later it was scanned or digitized or put in some server, anything that will be applicable. Then applies to all entities processing data, including private and public entities, even public sector undertakings, PSUs. All those are also now very well under the ambit of DPDP. Applies to entities outside India also, even if they do not have a presence in India, but they are giving their goods or services to people in India, as I mentioned in the opening remarks. People like social media companies or other cloud companies, even AI, now LLMs, chat GPTs and Claudes and those, perplexities of the world. Even if they do not have a company or a presence or a legal entity in India, but now all of us are using all these AI tools also, they are very well responsible under the DPDP Act to protect our information. Uh, Now, but the $1 million question here will be that suppose we upload something on GPT and ask it to summarize it, and it's a free account. And suppose our the all the questions being asked, the ethical aspects of AI and the legal regulatory aspects of AI is that, is this data entering the public cloud? Is it data entering the AI overall search capabilities for further refinement for future? Will this data be available to other people? Simply stating.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management, request a demo at complinity.com.
All these are questions which may not have direct answers, but another question which comes is that, will all this data be a subject matter of DPDP? May or may not be, because if it's a data, it's your data, but then it's not your personal data. It is suppose a corporate data, say a project report of a company, and you upload it and it goes, say, online. But it's not your personal data. So again, DPDP may not have still have the teeth to bite into that. And only personal data, digital personal data is being talked about here, not the corporate information or other kind of information, for which, of course, Information Security Act, cyber crimes, and then the agreements that you have with your customers, vendors, confidentiality clauses, common law, civil law, all of those things will apply. Applies to data fiduciaries and data processors. Applies across all sectors. It's a sector agnostic law. There is no industry, which is defined here, and special applicability for children's data. On the exemptions, so there are certain exemptions under Section 17 to which DPDP does not apply. For example, personal or domestic use. So, a data which is only for personal or domestic use, there the DPDP will not apply. Publicly available data, it's already there in the public, so it won't apply. Where the processing is necessary for enforcing a legal right or a claim, that's an exemption. Courts, tribunals, statutory bodies, they are required to process personal data to perform judicial, quasi-judicial, or sort of supervisory functions. There it is exempted. Even for law enforcement agencies, the police, the enforcement directorate, CBI, CIA, etc. So prevention, detection, investigation, prosecution of offenses, it's an exemption. M&A, corporate restructuring, there may be data to be exchanged between companies, even if it's a personal sensitive data, but under those transactions and under those deals, things have to be exchanged. Loan defaults and financial assessments. So RBI has special powers and special rules and regulations for getting that data, making that data public, etc. And even other entities, the regulated entities also have different sort of powers. Sovereignty, state security, public order, and research and statistical purposes. So these are some of the exemptions to DPDP where data can be used without the consent, notice, and other provisions outlined by DPDP. Now, rights of data principles, which is you and me. Right to access information. So if you have provided some information, you should also be able to access your information if you provided that information to somebody. Now, you must be also able to access it that through online, or you must have the wherewithal to see what did you submit in the first place at all times. Then right to correction and erasure of personal data. So if a wrong information has gone in, you now have a right to correct. And earlier we have seen cases going to High Court, Supreme Courts to direct the search engines to sort of remove something from the search history if that was probably casting a wrong impression or a wrong information, etc. Because something which enters the cache of search engine is very difficult to erase. But now, so earlier it was done through courts only. Now, even the Data Protection Board of India will have jurisdiction to handle all these cases, and one doesn't need to really go to High Court, Supreme Courts, or even district courts for that matter. And right of grievance redressal. So every organization must have a grievance redressal officer, GRO, and even the larger companies, which is significant data fiduciaries, and we'll come to the definition, need to have data protection officer, DPO, also. So again, you and I have a right of grievance redressal. We can suppose the app-based cabs. Suppose you feel some data has been breached by them, or you go to any store, Reliance store or a Chroma store or a Vijay Sales or whichever other electronic store you go, and you feel your data is being collected and it's suppose not you have some grievance related to that data. All these institutions, B2C institutions collecting your data, your and mine data, we will have grievance redressal officers, and where we can simply, just like ombudsperson in several other frameworks, it's a grievance redressal organization of the organization. We also have a right to nominate. So in case, I will not say you and I here, in case the individual expires, and what happens to his data then. So again, just like nomination facility, we have a data nomination also here, and right to withdraw consent. So everything is very consent driven. If you have the power to give consent, you also have the power to withdraw consent at any time. And after the consent is withdrawn, the data fiduciary has no right to sort of further process your data. So if the data fiduciary or the processor processed your data before you withdrew your consent, that is allowed, because the data was already processed until that point. But after that point, no further data processing will be done after you have withdrawn your consent. Now, core obligations of data fiduciary, which is the companies. Lawful purpose and clear notice. So these are very important. Lawful purpose. So again, the business has to be legit. You cannot procure any data for a purpose which is illegal, immoral, opposed to public policy, those kind of things. And a clear notice has to be given to the individual that what data, and we'll have slide on the notice also, what kind of data is being collected, how it is stored, etc. Then valid and auditable consent. So consent, also there are very clear provisions on how the consent should be valid, and there are some provisions around it, and we'll talk about it. And auditable. So there have to be audit logs maintained, some proofs maintained that the consent was given. Reasonable security safeguards. So again, this term was used even in the IT Act in the rules, where they said reasonable security safeguards must be maintained by organizations, companies, by implementing, say, privacy policies and ISO 27001 frameworks, etc. So here also it says there needs to be reasonable security safeguards for the protection of data, right? Wherever the data are being collected, stored, processed, etc. Then data accuracy and data minimization. Now, accuracy, of course, whatever you're collecting, keep it accurate. Do not, it should not get mixed up, and it should not get altered. Minimization is important. India versus other developed nations, the West specifically. When we talk to people there, we come to know that for example, things like your orientation, sexual orientation, for example, or your religion, or your age, for that matter. Age is a big thing out there, because it's not required to even doctors or medical records also age, unless the thing is very, very age specific. Otherwise, the age is also not taken in general OPDs, etc. And only for a need to know purpose, those things are taken. So here, their data is such a sort of abuse, or has been an abused commodity, that so much of information is collected, even which was not required. When we download the apps, they ask for so many permissions, and if the app is important to us, we have no option but to sort of say yes and move on. But why is the app sort of collecting your contact information, your gallery information, your location information, if none of that is sort of important for the running of the app? So these are some important things which even these apps will have to now, the millions of apps which are there on the Google Store, Apple Store, will have to now relook on their privacy policies. Even the mobile phone companies, for that matter, there are so much of personal data there on the mobile phones now, and what kind of data is being sort of shared through the apps or otherwise, and shared with their partners, the partners with the mobile phone companies, etc. So all that has to be seen. Grievance redressal mechanism, as I said, there has to be grievance redressal officer or data protection officer, depending on the size of the company. And even processors are accountable to the fiduciary. So the data processor that is there, there may not be direct liabilities or responsibilities under the law. However, they of course have contractual and all sorts of liabilities to the data fiduciary if they are processing the data on behalf of the data fiduciary. And fiduciaries have to, of course, comply with all other applicable laws. And what that means is that, like the IT Act, now only 43A has been repealed. The other sections remain valid. So you cannot say now for DPDP I'll only comply DPDP. Whichever other law applies, either the IT Act or there could be sectoral regulations, like the RBI may prescribe enhanced measures, security measures, and not may, they have surely prescribed through several rules and regulations for different kind of regulated entities. So all those are also applicable. In addition, DPDP also has to be satisfied. Similarly, for other sectors, telecom companies, there are other regulations. For insurance companies, there are other regulations. So all those laws also have to be applied for. And no impersonation or identity misuse. So companies have to ensure that one data is, for example, our Aadhaar and PAN card was given to a hotel when we were checking in, either of this, for example. And they have to ensure that the copy that they took, now that is not, our Aadhaar is not impersonated, and no other person is able to utilize that for any other purpose, either for taking a SIM card or gas connection, or so therefore those companies have to ensure, and such a big responsibility, if you just imagine that, where are they storing those files, when after they digitize it, and who has access to those, how do they ensure that that data is not getting misused? All that is coming under the governance of DPDP. And when it comes to DPBI, of course, fiduciaries will not conceal any material information from DPBI or any other regulatory authority. Engagement of data processors by data fiduciary. So it's like a contract, as I said. The contract must cover purpose limitations. So for what purposes will the data processor use the data for? What are the security safeguards where the data processor will now deploy? What are the erasure obligations? So suppose the contract is terminated, or the contract expires. Now, I'm sure the contracts also cover those kind of clauses which say that post termination, after the handover, you will delete all the data. Those kind of obligations must be there now even more. Earlier, they were as a good prudence, as a good contract. But now, even as per the DPDP, the fiduciary has to ensure that there are erasure obligations on the processor also, and there are audit rights, which again, good contracts and good companies used to have it, but they'll be now mandatory for the fiduciaries to have those kind of things on their consultants and data processors. But the fiduciary remains accountable. The responsibility and accountability to the data principal, which is the individual, cannot be passed on to the processor. Written contracts are now mandatory between processor and fiduciary. Security and breach notification clauses should also be there. If there is any breach, who will notify whom, within how much time, etc. When the data processor subcontracts it to a sub-processor, like a subcontractor, even those controls must be sort of defined somewhere. And vendor audits and due diligence. So again, all data fiduciaries must now ensure that they are doing adequate vendor audits and due diligence, especially on the data front, on the IT data front. What are the controls? What is the probability that the data can leak out, etc., etc. Especially the payroll processing companies who handle all this personal data. And there are many payroll processing companies and labor law compliance companies who handle all this PF data, ESI data, salary data, wages, all of that. We have to now ensure that they have all those reasonable safeguards now. Now, notice is a key requirement under DPDP Act. So a notice must be standalone. One cannot combine the notice with any other privacy policy, terms of use, or any other agreement. Sometimes, and more often than not, when we go for any login creation or any software implementation, download, etc., even apps for that matter, they may have huge agreements, which of course nobody reads, not even the lawyers, who when they are downloading from a personal perspective, they would not have the time or the bandwidth or even the inclination, because lawyers work by the hour only, so they're not getting paid for that anyways, on a lighter note. But those may not be read. But here DPDP Act says that standalone notice must be there, must not be mingled with the terms of use privacy policy, need not be very lengthy, very clear, plain, simple, no legal jargons, easily accessible through the website, app, emails, SMS, pop-up, onboarding page, etc. Prominently displayed, not buried in lengthy policies, and provided in English or a language understood by the data principal. There's a typo here over here. So by the language understood by the data principal. So if the data principal, suppose you're operating in suppose South India, and the data principal wants to see it in vernacular language for that matter, the company, the fiduciary, even has to provide it in the vernacular language. Means not just South, I'm saying wherever, even not just English and Hindi, even vernacular languages may be requested by the data principal and then has to be provided also by the fiduciary. Now, mandatory elements of a notice: what is the personal data that we will be processing, and what is the purpose for which we will be processing the data. So the manner of processing or use, and how to exercise your rights, like how will you access it, how will you correct it, how will you ensure erasure, and if there's a grievance, how will the grievance be taken, and how to withdraw consent. So again, giving consent and withdrawing of consent, both are important. And grievance redressal details, names, email IDs of the grievance redressal officers, and if there's any cross-border transfer which is applicable in this case, that also has to be mentioned in the notice itself. Now, what are the standards for a valid consent? Consent must be free, informed, specific, and unambiguous. And specific consent for separate purposes and types of data. This is the most important point. That means that if some data is being collected, say, just take an example of a hospital. Now, there's a IPD, internal patient department. That I think that's what is the full form of IPD. So if there's an admission which is being done, and the hospital is taking your KYC and other medical information for the purpose of admission or hospitalization. Now, the consent must be taken. You will be sort of signing consent that yes, you consent to, giving that data and documents, etc. Now, tomorrow, if the hospital wants to share this information with some insurance companies, or with some fintech companies, or with some AI companies, or with some research companies for the purpose of research, or some credit rating companies, or other rating companies, or other industry regulators, not regulator, but industry bodies, etc. Because regulator, if it's required by law, then they have to share it. So all those kind of purposes, if that medical facility, that hospital intends to share that, either for money or without money, like if they want to monetize it, or if there's a strategic collaboration, whatever that is, they have to clearly tell you at the time of taking your data, that these are the purposes for which I'll be utilizing your data. And if at that time you do not feel comfortable for certain purposes, you may sort of withdraw, from that kind of thing. But there'll be no bundling with other terms and conditions. So consent and notice has to be very separate. An easy mechanism to withdraw consent, and consent records must be maintained. And that's the reason this consent managers, which is a separate class of business and separate class of industry which is coming, will become very important in probably building such tech platforms where these consents can be given, withdrawn, it could be maintained as audit logs, etc., etc. The interface design of notice and consent, it has to be prominent. Notice may be presented along with a consent request in a single screen. However, it has to be prominent. Consent button has to be clear and separate. No dark patterns or misleading interfaces. Means you cannot say that you keep scrolling and automatically it gets accepted, or simply because you proceeded to the next page, therefore you have deemed to have accepted this. Things have to be white labeled. It has to be totally white hat kind of thing. No dark patterns, no surreptitious taking of consent, very clear, unambiguous consents. Otherwise, if these consents are not taken as per these guidelines, you can be sued before the DPBI, which is also a regulator and an adjudicator, and they can levy. Then will come, if you are a significant data fiduciary, like a large one with a huge impact, then the 250 crore and the penalties which have been provided may still be reality. Legitimate use under section 7, where DPDP, where no consent is required. So the difference between section 7 and section 17 is section 17 was exemptions, where the DPDP Act only doesn't apply. Here it says consent is not required for legitimate use, notice and consent, which means if you voluntarily are providing your personal data, being a data principal, so that's fine, that's a legitimate use, voluntary. Or say state benefits, say services, licenses, birth certificate, death certificates, or other state services, or say marriage certificates. So to issue certificates, if you have to provide another certificate. So, and for certain benefits of some schemes, government schemes and all, you need to, give certain data. So all that is a sort of a legitimate use, and they don't need a separate consent. State functions, sovereignty, security, etc. Legal obligation to disclose information. So again, this could be anything. As I said, if the regulator is asking, you got a legal. If the court is asking, if the enforcement agencies are asking any information, it's a legal obligation for you to disclose that information. Then, as I said, court orders is okay. I've covered. Responding to medical emergencies, public health emergencies, disasters, and employment purposes. So for employment purposes, thank God this legitimate use is already mentioned. The employer, of course, can take that data for employment purposes. However, the overall scheme will surely again still apply. You cannot monetize this data unnecessarily or sell this data to outsiders without taking consent. Employment data collected for the purpose of employment, stored again in a reasonable fashion so that it doesn't get leaked or is not accessed by people who are in an illegal way, or who does not have a need to know. All those things will still have to be maintained as legit, even in legitimate use. Now, significant data fiduciary. So government will notify depending upon volume, risk, type of data, and potential impact on integrity or sovereignty of India, or the security of the state and public order. So they will notify who is a significant data fiduciary. The chances are that these large companies like Ola, Uber, or Rapido, or Facebook, Instagram, Google, LinkedIn, these social media companies, or even Amazon, Flipkart. So e-commerce, quick commerce, social media, cab hailing, and any other large company which handles a huge volume of data, and the potential impact could be huge. They could be classified and notified as significant data fiduciaries. Either certain thresholds may come on users or turnover, or some way in some other methods, or even named companies. Companies could even be named that, okay, these are the significant data fiduciaries. So they need to additionally appoint a data protection officer. Normal companies need to provide only the grievance redressal officer, but they need to go through a DPO. Then they need to also conduct a DPIA, data protection impact assessment. So they need to see what are the sources of data, where is it stored and collected today, and how is it being processed, and what is the the impact of that data in case that data is leaked or breached, etc. So that impact assessment needs to be there as a precursor, on the data and its usage, and it's not a full-fledged cybersecurity or an IT audit, but an impact assessment, I'm saying. And then on top of it, they need to appoint an independent data auditor who will then conduct a full-fledged sort of cybersecurity audit. Now, international data transfer regulations, so they are permitted unless restricted by the government. No blanket data localization requirement. It can be notified case to case. But yes, if there are data localization requirements in other laws, it may be complied with. And in other regulations, other sectors, other industries, it should be complied with. Then Data Protection Board of India is the new board, DPI as it is called, independent adjudicatory body, and responsible for enforcing the act, ensuring compliance with the act, imposing penalties. Also will function like a civil tribunal focused on personal data protection. And it's a digital by design authority, has to be, is operating on digital personal data. So a digital by design authority through online filings, electronic hearings. So should be very interesting to see. And even establishes practice areas for consultants and practicing professionals. Now, penalties, the best one is the first one, the highest one, 250 crore, which has made the news. Failure to take reasonable security safeguards relating to a personal data breach. Second is 200 crore, 50 crore lesser, but still quite a lot. Failure to notify the board and data principals of a personal data breach. So every personal data breach has to be notified. But that's quite a specific one also, because first one was, a lot of steps and procedures and SOPs and, the whole manuals will come. But in the second one, it's a, failure to notify and 200 crore. That's a big one. So I think incident handling, incident management, incident reporting, all that has to be very, very up to the mark. Failure to fulfill data principal rights. So up to 200 crores again. So right to access, correction, eraser, grievance redressal, all that. And this is on the data principal, violation of duties of data principal. So data principal also has certain duties, and in case they do not fulfill their duties, up to 10,000. So why 10,000? Because this is applicable to individuals and the data principals like you and me. So there, of course, where will we get 200 to 50 crores to pay? So 10,000 rupees has been sort of prescribed. Compliance roadmap for organizations. So I think we are towards the end of the webinar, and last few slides on the thing on how to implement and the practical aspects. So one is the data discovery and mapping itself. That is how you have to see what are the several sources of data, and map that, where is it coming from, where is it going, how is it being stored, retrieved, accessed, backed up, etc., etc. So data discovery. Then gap assessment against DPDP requirements. So DPDP requirements are there, very clear, acts and rules, and further rules may come up. But in the meantime, even when further rules are not there, whatever rules and act provisions that exist, one has to do a gap analysis clause by clause. That are we complying with this clause? And either the companies may do it in-house, or they may come to law firms or other experts on data privacy, or IT experts for that matter, because it's a very techno-legal topic. It's not fully legal, it's not fully technical, it's a techno-legal topic. So a legal expert having knowledge in IT and procedures, or an IT expert having knowledge in laws, I think both should do wherever you get your comfort, or else internally. Consent and notice redesign, and the notices and consents as have been talked about in the act. Incident response, as we saw that a single or a series of breach of incidents to the DPPI may cause you to 200 crore. And vendor contracts may need to be amended, because if the vendor is processing your personal data, they may need more clauses and obligations being passed on to them also for access, erasure, and for making it confidential and stuff. Operational readiness checklist. So what is the as per the DPDP, the whole checklist, line by line, clause by clause, are we really ready to implement everything? Policy and contract drafting. So whichever policies need to be drafted, whichever contracts need to be drafted or amended, all that needs to be seen. Data protection impact assessment and audit support. So for significant data fiduciaries, this thing has to be done. Ongoing compliance monitoring, updating our boards and audit committees and risk councils, risk committees, trainings, governance, audits, etc. So these are the broad highlights of what it entails to be compliant. But little more grounded steps on implementation steps on the ground could be, at the bare minimum, get a gap assessment and operational readiness review done under the DPDP Act. This will probably be a clause-wise operational checklist. Okay, experts have been doing it anyways. So clause-wise checklist where somebody can tell you, okay, this is what is required by the law. and they will map what is it that you have, and therefore what you don't have is the gap, and then can come the recommended next steps. So 3-4 columns, but a very exhaustive one on the act and the rules, I think will help you do a dipstick or the or where you stand even today. Second would be actual implementation. So this could entail reviewing and updating of, as I said, vendor processor agreements, your key policies, SOPs, contracts, or amending them with different contractual clauses, designing the notices and consents, and withdrawal of consent mechanism, incident response procedures, SLAs of those procedures. How fast are you sort of uh, satisfying or remedying, or means response time, reaction time, resolution time, all of that. Then providing implementation support and stakeholder training awareness sessions. And then third could be a full-fledged cybersecurity audit, which some large MNCs and especially service companies or other companies might anyways be doing it, but that will also be important specifically to assess the effectiveness of the DPDP Act implementation. So that's about it. This was at a high level. I'm Dr. Sumit Pava and co-founder and CEO of Complinity Technologies, senior partner eMinds Legal. My both the email IDs are mentioned. You could please take a note of it, click a picture, and if there are any queries or any support that you need on any of the provisions of the Act or the rules, or on the gap assessment or implementation or the operation readiness checklist, our company's, Complinity, as Divya had introduced, is a compliance software, India's leading compliance software, and it helps companies comply with the laws. And DPDP is one law where, of course, we have the full checklist of DPDP Act and the rules, and it can help you ensure that every line item is covered and every line item you're tracking. And similarly, eMinds Legal, as a boutique corporate law firm, can help you actually implement, designing of the notices and the consents with the help of course, the cybersecurity professionals, which eMinds has. They can help you with the gap assessments and the service and the consulting aspect of the whole thing. So while eMinds is on the consulting side, of course, practicing on the DPDP, Complinity is on the product side as a compliance software, not just for DPDP, but also for all the laws, including labor laws, IT laws, company law, tax laws, everything. And Complinity is working with today with 350 unique client groups spanning 1,500 plus legal entities all over India, including listed companies, public sector undertakings, MNCs, and a lot of companies above 100 crore top line. So broadly, this is what I wanted to share. I hope you would have, I took around an hour or so, but I hope you would have gotten some value out of it. Uh, Excuse us for the format, because these large number participation in webinar format requires the format to be monologue. I'm not used to speaking in a single stretch without any public or audience participation. I'm known for sort of engaging, and it has to be collaborative, but then hundreds of people can't talk to one, and it'll disturb the format. So that was the format. Over to you, Drivya. I know there may be a few questions, etc. But Drivya, as a moderator, over to you for the next steps. Yeah.
Thank you for such an insightful presentation, Dr. Sumit. Let's take a short break before we move on to the next segment of today's session, that is Q&A. During the break, I request the Complinity team to play a short video.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.
Thank you everyone for participating in the poll. Now let's move on to Q&A session. So the very first question is from Mr. Pavan Kumar Agarwal. He writes, clients of this DPDP compliance software. I believe this is not clear.
Yeah, and also, Drivya, I would recommend you can only mention the first name to protect confidentiality of the this thing also,
Sure.
but also to recognize the person who is. So I think the first name should be good. Yeah.
Sure.
Hmm.
So the next question is from Mr. Shehzad. I have a question regarding the DPDP Act. Is there any prescribed requirement or mandate specifying which documents should be verified to establish that an individual is a parent or a lawful guardian before obtaining consent for processing a child's personal data? If
Yeah.
so, what documents are considered acceptable for this verification?
Yeah, so I think Shehzad, the parent and child relationship can be established through Aadhaar cards, through passports, etc. So only when it is required. So generally, I mean, parents are lawful, can give consent, and if somebody is asking for to establish your credibility or a relation as a parent and child, you can then of course you there are these PAN cards and Aadhaar cards and passports should be okay.
Next question is from Anandan. Garment apparel industry. What are the dates covered under DPDPA? Only user or employee personal data or buyer data or application data also include. To implement mid-size, how long will take and what is the approx cost for the implementation?
Yeah, so Mr. Anandan, garment industry also data would be normal only in the sense your customer data, vendor data, employee data, any individual that you are sort of interacting with and all individual personal data which identifies that individual that would be covered. And again, to mid-size or you're saying implementation, it all depends on, again, difficult to answer this, but you can surely approach us, and we can see the scope of work and then accordingly advise you on the timelines and the cost. But just to give you a ballpark, suppose a company with say one manufacturing plant will be different from company with say 30 manufacturing plants, so that will differ. But even if you're a mid-sized organization, at the bare minimum 2-3 months, again the very high level ballpark without getting any details I'm telling you, minimum 3 months you must imagine it should take to implement, because you are looking at your contracts, you're looking at your policies, you're looking at your procedures. But it can even be longer in case it requires amends on the IT front. Some, maybe you never know, maybe your internal systems are not secure enough or the infrastructure is not good. It may require you to change your infrastructure and some go on some secure clouds, etc., or change the way accesses were given to people. So it may even take longer. So it all depends on how mature is an organization, what kind of controls you already had, etc. So therefore, with less than 12 months remaining, of course we do not want to go till the last date till May 27 before penalties start kicking on us. So I think the best time to start is now, and you still have the luxury of time. Even if it takes 6 months, you still have the luxury of time. For cost, you can please, Nandita, if you can mention my email IDs, both the email IDs, you can please write to us, and I'll direct it to the appropriate person to give you the consulting and proposals.
Thank you, Dr. Sumit, for answering this. Next question is, consent manager or every organization is external resource, or can it be an internal team as well?
So it's a good question, Mr. Sitaraman. Consent manager, while there are rules for consent manager, and it is defined that who can be consent managers. And by the way, there was one typo in my slide brought to my attention by my team. I had mentioned that the net worth of the consent managers has to be 200 crore. Sorry, it is not 200, it is 2 crore. Sorry for the typo. But it's so while the rules are clear about consent managers and who can be and they have to register and what will they do, what is not clear still is that whether it's a very valid question that whether all consents need to be routed through consent managers or through internal teams. And my best guess is that mid-sized organizations or organizations below a particular threshold should be able to do internally also, and only the larger ones beyond a particular threshold should need consent managers, because small organizations should not be burdened with another cost of a consent manager and and giving your data first to the third party and stuff like that. So I believe it should be doable, but let's see how the clarity emerges.
So the next question is the video recorded by CCTV camera also considered as a personal data?
Yes, so any information which personally identifies the individual is a personal data, and therefore video recording, completely identifies you. Forget video recording; it's a very high level. I'm saying even a biometric, which your fingerprints, etc., your thumb impressions, that is also personally identifiable. Your iris scanners, the face ID that is there by which the gate opens, suppose, or the like you go to Digi Yatra, and we when we travel through Digi Yatra and all that is also personal data, including now CCTV cameras footage.
Okay. So Gunjan is asking, is the phone number also a personal data?
Yes, quite counterintuitively, but yes, since it also identifies you phone number. Now my number is now, for example, for the last 20 years, I'm using my own number, and one doesn't now change numbers easily, because that is where you are actually it becomes your identity. And just on a lighter note, if the celebrities, the Bollywood actors and all, if their numbers were easily circulating, you can imagine what kind of havoc this can play. So tomorrow, the Amitabh Bachchans and Shah Rukh Khans of the world, they also would have their bank accounts in the same banks where we keep our money. Could be HDFC, Axis, ICICI, wherever else, except the fact that they have a few extra zeros, in the bank balance. So if the bank could, just put their mobile number out, just imagine what kind of havoc it can create. So it is a personal data. Yes.
Next question is, if the DPDP applies to the individuals, so can we store B2B transaction details and send marketing communications?
I'm not very clear of the question. If it applies only to an individual, can we store B2B transaction details and send marketing? So, as much as I could understand the question, and Drivya, correct me if I'm wrong, you're also an expert on DPDP. So, yes, the individual data you cannot do, that's covered under DPDP. If it is only corporate information, compliance information, that will be covered with confidentiality clauses and other, laws. But DPDP will not apply to that. But it doesn't mean that you simply email out or upload on the cloud any confidential information of a corporate saying it's not covered under DPDP, because that's covered under confidentiality and other contractual arrangements. Anything, Divya, you'd like to add over there?
No, you're absolutely right, Dr. Paga. The information need not to be covered under DPD.
Yeah, right.
Okay, moving on to the next question. Whether Residential Welfare Association will come under the ambit of DPDP Act?
Yeah, so all entities, will come under DPDP Act. Not even entities, actually, I will say all persons. I did not use the word person, because person may confuse, are we talking of the data principal or are we talking of the data fiduciary? But the Act does not describe data fiduciary as a company or an LLP or a society or a trust or an RWA. And therefore, it says anybody who collects data and who has a means to collect the data and has a purpose to collect the data is a data fiduciary. So by that definition, even an RWA would fall under that. And if they are collecting personal data, say, again, your KYCs, your Aadhaar card, PAN card, and of course, they may have forms saying who all are your family members, what is their age, what is their marital status, what is their relation. All of that data, in my opinion, will become confidential and covered under DPDP.
Okay, moving on to the next question. Voluminous data is frequently essential to India's booming IT sector, particularly in AI and big data analytics. How do you see this as a challenge, and what remedial measures should we imbibe to enable and guarantee innovation while adhering to privacy standards?
Yeah, so voluminous data, of course, is there. There are millions and millions of records getting generated, but I think so is the computing capability. So are the servers and the cloud servers and the infrastructure. I think all of that has evolved, and even what I hear is more and more investments being done in data centers, etc. already by the big people, big companies. So. I don't think the volume should be a challenge, as long as the IT infrastructure, for example, if if a data, if for example, if you, Pratyush, if you are here on the call, if you are filling in a simple form and putting in 10 fields of yours. Now, for you, it's a simple form of 10 fields and submitting it. behind in the database, you could be 1 millionth record, right? There could be 1 million records already sitting there. Doesn't matter, doesn't harm you. The computing capability is good enough, where people like Swiggy, Zomato's, Flipkart's, Amazon's, Porter, Uber, Ola, they are actually doing millions and millions of transactions every day, even banks, financial institutions, fintechs. So the infrastructure already exists. Volume should not be a problem. What the If the processes are set right, the policies, processes, the exception handling, the breach notifications, the controls, the ITGC as they call it, IT general controls, all the audits, procedures, I think things should be good there.
Okay, so there is another question from Sita Raman. He's asking that are the software or service providers, including cloud servers, do they fall in the category of data collectors?
They could be, yes, of course, data collector, but the data collector word is not defined. The words defined are data fiduciary or data processor, and they could be either. So if the software, say Complinity software, I just told you about, I'm a co-founder CEO of Complinity. So if we collect personal information of users, that becomes the personal information. So then we are a data fiduciary to that extent. And E-Minds Legal, if I talk about, again, taking the closest two examples, if E-Minds Legal, say we have a accounting, tax, payroll vertical also, and if they are processing payroll information on behalf of a client, then they will become a service provider or a data processor. So that is one. Now, cloud servers. So of course, we also deploy cloud servers both in Complinity and E-Minds Legal. We use Amazon Web Services, we use Azure also, etc. So they would be data processors, and even AWS and Azure, of course, they are reputed companies, they're very large companies, they already have all those controls. But should anything wrong happen from their side, they are equally responsible under the DPDP Act as data processors.
Moving on to the next question. If the information available in the public domain, example website, is used by individual or company, does it violate Act and the law?
No, so information in public domain is mentioned in the section 17 exemptions. So public information is not covered under DPDP Act, and then it doesn't violate.
So,
But here, I would go ahead and say that if the information is available in a legit format, means there is a dark web, as we know. So if your credit card or somebody's credit card details is present on the dark web, and somebody says, no, it was a public domain and I picked it up from there, so that would not be legit, in my opinion. That's quite logical over there. Yeah.
Thank you. Moving on to the next question. If Residential Welfare Association comes under the ambit of DPDP Act, the data of the residents entering in NBH without the written consent of the residents will violate the provision of DPDP Act. This action taken place after DPDP Act come into force, but before the rules notified.
Mr. Joseph, the query is not very clear. I don't understand what is NBH also. Could be some acronym which I don't understand. So at a high level, again, I say RWA is very well within the ambit of DPDP. It is not exempted. And if it is accepting any data, any personal data, it has to comply with the DPDP Act. That's what at a high level. But if your question you feel is something else and not being answered, you could please mail your query again in some other articulation to us, and we can again look at it.
Moving on to the next, can the data processor also be data fiduciaries or do they have to be separate entities?
Data fiduciary is somebody who is like a principal who collects the data and who has a means to collect the data and who has a purpose to collect the data. It's like the main end organization. But data processor could be an intermediary. Now, it is quite possible that, for example, say TCS or Infosys, they could be a data fiduciary when they are collecting data for their own organization, but they could be a data processor if they are processing data on behalf of a client. So one could also be a service provider and collect data on behalf of the client, and also a data fiduciary when they're collecting data on their own behalf. So I think that's my answer.
Okay, so the next question is asked by Rajkumar. If CCTV monitoring capture like personal information from mobiles or other locations where we are keeping and if used for any illegal purpose?
CCTV monitoring capture like personal information from mobiles or other locations where we are keeping. I am not clear of the question, Divya. Can you make sense out of it?
No, the language is
Yeah,
quite
it's not very
unclear.
clear. So, Mr. Rajkumar, if you can again email the query to us, we can have a look at it with your. But whoever is emailing to us, please mention your full credentials, mobile numbers, everything, your organization designation, so that at least we know who you are and accordingly we can respond. Yeah.
Okay. Another question from Mr. Rajkumar only. He wants to know what are the fines under the DPDP Act. I believe, Rajkumar, this has been answered by Dr. Pava in his PPTs only. So, just to give you a brief, there are around penalties up to 50 crores which are mentioned in the Act.
Yeah.
Moving on to the next question. Browser cookies collecting data will be a no-no after DPDP, is it?
No, it is not like that. Browser cookies can be collected. However, you have to tell the user. Even today, when there is a consent which comes, which says that you accept cookies, accept all, etc. Those kind of notices come. Maybe the format and the content of notices and the consent may change a little bit depending on the and rule are requiring it. But then with consent, you can surely collect it. However, I think what is missing is that after having given my consent, when I sort of accept cookies, I do not find any option, or maybe if I've missed it, to withdraw my consent. That I don't know whether that exists or not. And those things also have to be there. So have clear notices and consent to collect it, have clear things to withdraw it, and then all the other paraphernalia like grievance officers or data protection officers, if you are a significant data fiduciary, all those things also have to be complied with. Then you can collect.
Okay. Moving on to the next. Related to rights of data principle, as HR department, we collect the data and we don't provide access to the same. Is that okay?
Collect the data and we don't provide access to the same to whom? Not very clear.
To the data principle, the HR department is collecting the information from the data principle and they're not providing the access to the same to them only.
So, for example, Ms. Rupa, as an HR department, you're collecting some information from the data principal. Now, if the data principal asks you about his own information, then you may give it. In fact, you have to now give it. But employment is also one of the exemptions under Section 17 of DPDP Act. So, therefore, employment data is not covered under DPDP, right, Divya?
Right, right.
Right. However, even as a good prudence, the employee can ask for his own data. He cannot ask for any other's data, but he can ask for his own data. And, that you should provide access to him for his own data. That much you should do.
The next question is question related to personal data, consent and use. How should companies manage consent withdrawal practically?
Yeah, so Sunita, this you have to see depending on your industry, depending on your your size, industry, etc. So you have to the way you are collecting the data, in a similar way you have to sort of manage the withdrawal of the data. It could be physical form, could be an IT form, could be workflow. Some things you have to just figure out, or it could be an email request also. Those kind of things will depend on your infrastructure and what kind of business you are in.
Moving
Yeah.
on to the next question, which obligations like consent, notice, etc. are exempted for a company engaged in research activities, or are all the obligations under DPDP exempt for research-based companies?
Which obligations like consent are exempted for a company engaged in research activities, or are obligations to be exempt? So research organizations are not exempted from DPDP. However, research activities are exempted from DPDP. So, if the organization is a research organization, it is very well covered under DPDP. But if some data is being used, for research purposes, then that is sort of exempted. Yeah.
Also, adding to what Dr. Pavas just
Yeah.
mentioned, the data, whatever you are collecting for the research purposes, also should not be used to take a decision against that data principle only. So, moving on to next.
Yeah, I think that's a very good point, Trivia. So, because research is always aggregated. Your individual information is taken for an aggregate research. So that data should not become a victim of, by contributing that data line item to the research. Yeah.
Right.
Yeah.
So next question is, how does a data principal get to know that data got breached from a particular person or an entity?
So, there has to be breach notification. So breach notification has to go to the data principal also, and also to the DPBI. So there are clear provisions in the DPDP Act for breach notifications, and that has to be complied with.
We seems to have received a lot of interesting questions from the audience. Dr. Sumit, would it be okay if we extend the session by another 10 minutes?
Yeah, it is 1:35. We are already crossed the 5 minutes, but that's fine. I'm available. Yeah, so we can extend for another 10 minutes till 1:45.
Sure. So the next question is whether notice and privacy notice are the same thing, or will be applicable to all the industries regardless of size, complexity, and type of organization.
Yeah, it's the same thing, notice or privacy notice that you call it, but it's different from a privacy policy. Privacy notice need not be confused with the privacy policy, but yeah, whether you call it a notice or a privacy notice is the same thing. Yeah, and applies to all industries, all companies, regardless of their size, complexity, etc. Yeah.
Another question from Mr. Rajkumar Oli, who has currently right to audit consent, whether Data Protection Board of India or any other entity.
Yeah, both have, Data Protection Board of India has the right to audit. Your information security auditors have a right to audit. Your statutory auditors have a right to audit. Your compliance auditors have a right to audit. Your internal auditors have a right to audit. So, and maybe other regulators, say if you're a bank or a financial institution, Reserve Bank of India has a right to audit. If you're an insurance company, IRDA. If you're a telecom company, DOT, etc., TRI. So all those people have right to audit. Yeah.
Okay.
Also, Divya, you may, for better participation, if you may capture questions from several different people also. So if there is some
Yeah,
question repeated from somebody, you can probably take it towards the end in the interest of time and move
sure.
to your future questions. Yeah.
Sure. So there is another question from Mr. Saurabh Gupta. The challan and the summons sent through WhatsApp to an individual from any regulatory authority or investment authority or enforcement authority, then will it be covered into DPDP Act? Secondly, when we upload any file or documents, etc., to any free website for compressing, editing, etc., and our data went to that particular website, will it be treated as a consent? Will it cover under DPDP? Who will be the data fiduciary in that case? Please suggest.
That's a very detailed, long question. So, challan and someone sent through WhatsApp from by a regulatory, will it be covered under DPDP? So, yes, that will also be covered under DPDP, because challan summon is also personal information. And when you upload file documents to any free website, etc., for editing this, that, again, if that document personally identifies you, then it will be covered under DPDP. Yeah.
Okay, so there is also a second part of the question, that when they upload the file to any free website for compressing, editing,
Yeah.
and the data is when there, so will it be covered under
Yeah, I
DPDP?
just answered, no? So if the data is personal, if the data is corporate, B2B, etc., then of course DPDP doesn't apply. But if the data is personal, even on the website, then it is a personal data and it applies.
Thank you for answering. Moving on to the next. Consent manager, grievance officer, and the data protection officer can be the same person, or it should follow segregation of duties and any qualification required for them.
Uh, See, data protection officer and grievance officer can be the same person also. Depends on DPO is not even applicable to all the companies, but to SDF, significant data fiduciaries, it can be the same person. Consent managers, today it has been identified as separate companies only. So let's see whether internal consent managers as individuals is notified, not notified, and we can look at them.
The next is whether the consent managers will be required to appoint by private companies, small companies, HUF, LLPs, partnership firm. If yes, then how and when? Please suggest.
No, the consent manager again is not clear in the rules right now. Who needs to appoint consent managers and all? So let's see how the rules come up and see. Right now, only who can be a consent manager that is sort of described.
Moreover, at the beginning of the PPT, Dr. Sumit, you mentioned that these are the provisions that will come effective within till November 2026. So we can wait till then for benefit.
Yeah.
So next is any specific email address for DPBI where we can report any data breach within 72 hours.
DPBI, I don't think where DPBI itself has not been formed till now, and it is under the process of formation. So once DPBI is formed, I'm sure all those email IDs, addresses, all those will come.
Next is, are there any timelines defined in DPDP Act to erase the data?
I don't think any timelines have been prescribed under the DPDP Act for erasure of data. I think it is on. I think it's only the minimization of the data, that is one, and only when the purpose is valid, you can keep the data only till that purpose. And if the purpose is over, then the data has to be erased. Or else, if the data principal is asking for an erasure of the data before that, then the data has to be erased. But there is no one size fit all, because every data is different, every transaction is different. So there's no standard erasure timeline.
Okay. Moving on to the next question. Telecom SIM providers, insurance companies may have to retain our data for as long as it is valid. Is it not? Though they can't do marketing or sell our data to others.
So this will depend on those TRI regulations, DOT regulations, IRD regulations. I'm not an expert in either. So therefore, if those regulations ask them to provide the data, forever, then so be it. Then that's a valid thing, because those are specific regulations and other laws will also apply equally.
Okay. The next is, can we create privacy notice and consent request form on personal data processing in one document, or it should be separate?
It can be in one document. However, it should be again very clear, unambiguous. You cannot mix it with any other thing, like any other terms of use, privacy policies, or any other website text, etc. At best, you can only combine a notice and a consent. That's what seems like, unless any other circular or notification comes closer to the date and it changes. But for now, it looks like it can be done in the same also.
Okay. Next question is from Mr. Deepak. We are a software company and provide a document management solutions for B2B customers. We store customers' data on our servers on their behalf. So will it fall under the DPDP? How will the DPDP Act apply?
Again, Deepak, the B2B data is not subject to DPDP. However, your confidentiality clauses with the agreement will apply. But if that data also contains some personal data with respect to email IDs, mobile numbers, bank information, financial, medical, or any other data by which an individual can be identified, it could be even directors' information or KYCs or etc., ITRs or other things. Then, and if it's on the same server mixed with other data, then you have to, of course, DPDP will apply on those servers.
Okay. Next is, if an employee exercise their rights to erase data, what employee records can HR legally retain for payroll, compliance, and statutory purposes?
Yeah, it's a good question. Although, Sunita, as per Section 17, employment records are outside the scope of DPDP, though you need to exercise reasonable care that the data doesn't go out, and it's not that that data can be shared with anyone. But DPDP cannot be is not applicable on that employment records. So, Divya, would you agree with that statement, and would you like to add anything?
No, I totally agree with your statement.
Yeah, so therefore this is, I think, one example where as an employer you may need to permanently record the payroll data, compliance data, say PF, ESI data, all of that data, because you may have done filings and tomorrow you may have inspections, etc., even after the employee leaves. So you may need to retain that data. Yeah.
Okay, moving on to the next question. Consent withdrawal from HR perspective, is it applicable?
So it's not, because employment is outside the scope of DPDP. Yeah.
True. Next question is, in legitimate uses, do we operate on the principle that consent is given or that consent is not required, thus not requiring fiduciary processes to maintain records or comply with any other obligations?
Give me a second. The question is not clear. Let me just reread it. Okay, in legitimate uses. Yeah, so I think the principle is that the consent is given or the consent is not required in legitimate uses under Section 7, right? Yeah.
Yeah. So we can see that there are a large number of questions coming up. Unfortunately, in the interest of time, we won't be able to answer all of them during today's webinar. So we'll do one thing to ensure that none of your queries go unanswered. We'll compile all the unanswered questions along with their responses into a Q&A document and share it with all the registered participants via email.
Yeah, that'll be nice, Divya. Yeah.
Thank you for your participation, Dr. Sumit.
Yeah, thank you very much. And I also want to mention that thanks for the opportunity, first of all. And DPDP is a amazing piece of legislation, India's first data privacy law. And I think it's a techno-legal subject as I spoke. And it is important that we start the implementation steps now because May 27 is the final deadline where everything becomes applicable and penalties are quite high. So, and lawyers again, lawyers alone, the legal departments alone may not be able to implement it. The IT departments alone may not be able to implement it, and you may require external consulting, etc. So I think this is the right time for implementation, and we will be also. I mean, this is a subject close to my heart. Also, I've been practicing as a cyber lawyer, corporate lawyer, and cyber lawyer for many years, and handled several cyber crimes also. So we'll be doing many more series of DPDP on specific aspects, say on notices, consents, and few other aspects of DPDP. More deep dive now, since we have covered the overview today. So whoever has attended today, some of you have left also in the, because we have crossed the time, but many are still there as we speak. So please join us for future webinars, and you can, all the queries also, will keep making a compendium of all these queries, and these are very valuable queries, very precious queries. And we'll try to see how do we share all this with you, and we'll keep coming back to you. And my LinkedIn is also there, in the chat box. You can please connect with me. I'm very active on LinkedIn. Not only sometimes I post information about these things, but I also very actively post on leadership and emotional intelligence, which is an area where I did my PhD in. So happy to connect with you on LinkedIn as well. Yeah. Thank you very much. And just one last thing, my email IDs were also mentioned by Nandita in the chat box. So if there's any help that you need from us in terms of implementation or the software or anything of that sort or any query, please reach out to us with your contacts, designation, organization. We'll come back to you. Okay. Thank you very much. And thank you, Divya, for the opportunity.
Thank you so much.
Yeah.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management, request a demo at complinity.com.